Constitutional Court is expected to deliver the final judgment on the long-running Please Call Me case that's between mobile operator Vodacom and former employee Nkosana Makate. Joining us now is Kevin Smith, copyright legal analyst. Good afternoon to you, Mr. Smith. Thank you for joining us. Vodacom reiterates their argument that it was just an idea and that they implemented the whole concept, and therefore Makate doesn't deserve anything more than the 8 million that they have offered him. What are your thoughts with regards to the arguments we've heard in the court today?
Look, I think those are arguments that are expected from anyone in Vodacom's position who has to defend having to make a large payout to one of their former employees. But I do think that it's a disingenuous approach, only because part of what their argument is saying is that MTN had made a similar rollout before they had actually rolled out the Please Call Me concept, saying that the idea, had it not come from Mr. Makate, it would have come from the industry, so to speak, which again, in my view, is inaccurate because the fact that it was used from Makate makes the argument that it would have been available in the industry sort of an irrelevant point. So I don't think that it is something that should be taken too seriously, although that is why a lot of this argument has taken place in the first place. But if they had felt that the concept was just an idea and he wasn't entitled to any payout, then the matter wouldn't have gone through the courts all the way to the apex court as it already has.
But in terms of the copyright law here in South Africa, do you think they have a leg to stand on? Do you think they're just dragging it out, hoping to find a loophole so they can stick to the offer that they have given him already?
Yeah, look, I think in terms of our copyright law, we have to understand two things. We have domestic copyright law, and then we also have international copyright law. And the international copyright law is obviously to make all copyright standards across the globe pretty much standardized, given that within jurisdictions things might change. But this issue is not just based on copyright, it's also based on contract and the law of contract in relation to employees and the employee and employer relationship. So with that being said, I do think that, of course, Vodacom is trying to use any defense at their disposal so that they don't have to pay Mr. Makate what his idea was in fact worth. And if you look at it from a different standpoint, you will see that recently certain of the shareholders, in particular an initiative called Yebo Yetu, which is a minority shareholder scheme aimed at stimulating more black shareholder ownership within Vodacom. They have actually laid an opinion saying that giving Mr. Makate the value of his own quantum, which is within the billions, would be disastrous to shareholder value, and it might suspend dividend payouts to certain of those shareholders for years to come. So it's clear that Vodacom is taking into consideration a lot more than just the concept itself, which of course it is entitled to do because it has to protect itself as a company. But I bring that to your attention to just bring it to light that there are other factors in play. And it's not just a particularly law-related or employee-employer-related issue. There are other issues like your shareholder value, the company going into potential debt and losing a large portion of their revenue, which is also why Vodafone, the international parent company, has also wanted to interfere in the matter. So it's not just something that hinges just on the law itself. If that were the case, then the matter wouldn't have gone this far, all the way through the Crown Court and the Apex Court.
And I suppose the importance of this case is that whatever outcome we realize, it sets some kind of precedence for other cases that can follow. One of the arguments from Vodacom is that not all evidence has been considered by the courts of law, and if they have been considered, they were not considered correctly, particularly that Supreme Court appeal ruling that set aside the 47 million, saying that he deserved more, Makate, in this case. They're arguing that this be set aside. What aspects of this case do you think this might make this particular decision a successful one?
You know, I look at it from the following standpoint, and this was actually said in the SCA judgment itself, in them coming to a determination that they should overturn the High Court's judgment. The SCA had made a very profound insight, saying that the High Court had relied too much on expert opinion. And the reason why they say that is that an expert does not replace the function of the court. So the opinion of an expert is only there in order to help the court make its own determination. So this matter shouldn't have been sent back to the Vodacom CEO for further determination in the first place, because the court should have taken both quantums and both documentation substantiating the quantum put forward by Vodacom and the quantum put forward by Mr. Makate, and then they should have made their own determination. And that, I think, is a very correct assessment to make, because what Vodacom is doing is that they place such a wide discretion on the expertise of the Vodacom CEO. And that means that the court isn't actually coming into the arena to actually make its own determination on the merits of the case, because it has already been set out that he is entitled to compensation. He's entitled to a percentage between 5 to 7.5%. So the matter didn't need to go back for determination. They could have taken both quantums and they could have then made a fair assessment, because it hasn't been disproven that Mr. Makate's quantum is in fact incorrect, even though there are some considerations that were not taken into account, and that the determination of accrued revenue is different to that of what Vodacom determines. But there is sufficient documentation, financials, and substantiation from both sides for the court to have made its own determination. So I think that's where a big oversight lies, and why the SEA decided to overturn the High Court's judgment.
Of course, this is a developing story. Thank you, Mr. Smith. We certainly appreciate your insights. He is a copyright expert, telling us what we can expect and giving us some kind of sense with the arguments in the Constitutional Court today. Now we take you back.